Hi, everyone, and welcome. It's Denise Brown from the Caregiving Years Training Academy. Thanks so much for joining us. This is our fourth day in our Beginning Again retreat. Today, we're going to focus on our loose ends, and Joan is going to kick us off with a presentation about settling the estate. So, Joan, take it away.
Thank you, Denise. So, having settled my mom's estate as the executor, and then very soon, actually, while I was in the process of that, moving into a job as an estate attorney, I think I've got some perspectives that might be a little bit unique. That said, I am not practicing now, and I am not giving any legal advice. This is purely educational, informational. Just recognize that the things I call things, so for example, in Delaware, we have a register of wills. Where you are, it might be the probate court. Certainly if you're in Kenya, it's going to be called something else. So the terms are going to vary and the rules will vary slightly, but kind of the overarching themes and particularly the issues and the way of managing those that I'm going to talk about, those will kind of be the same. The process part, I'm just going to give a quick overview. I'm assuming that it is a testate estate, meaning there is a will. If it's intestate, a lot of the same things I'm going to talk about will apply, but it's just the procedure's a little different. If there's trusts or if you're acting as a trustee, a lot of the things are going to be the same. There just might be some nuances that are a little bit different. So before you begin, you really need to take a gut check. It is a long, tedious process. I would tell my clients this, the first meeting, I would always tell them at least a year. And none of them would believe me. They would not believe me. Usually by about month 8 or 9, they would start to come to see that, yeah, I was kind of right. So expect it's going to be a long haul and expect that there's going to be a lot of tedious stuff that you're going to have to deal with. If you can expect that up front, then dealing with it later is going to be a little bit easier because you're not going to have to be dealing with an unmet expectation that it was going to be all easy. So should you agree to do it? So, someone asks you to be their executor when they're making their will. They may not die for 20 years, right? You might say, yeah, I think that's great, I'll do it. But 20 years later, you could be in a very different situation. So just recognize, just because you said you would do it and you're named in the document, you do not have to. You can say no. And you really should check in with yourself about, are you physically able, right? Maybe when you said you would do it, everything was great. Now you're battling an autoimmune disease, right? Maybe emotionally things have changed and you just don't have the bandwidth for it. Your situation might be different. Maybe you've joined the military and you're deployed, or maybe you didn't have kids, now you do, and one of them is special needs. It might be that things have changed in your life where maybe you should not say yes. You also need to make sure that you understand the potential liabilities of acting as a fiduciary and what being a fiduciary really means, right? So as a fiduciary, you're in a position of trust. And you are expected to act in the best interest of the estate, not in your best interest, not in the best interest of the beneficiaries, but in the best interest of the estate. You're expected to do it and take, I'm going to use the term reasonable and prudent care. Different states might have different language, but what it basically means is, you got to take care of the assets of the estate. You got to do your job with diligence. You can't just blow off deadlines and take the estate money and decide, oh, I'm going to make a bunch for all the beneficiaries and start day trading, right? That's not being a fiduciary. You might also want to consider the family dynamics. So if there's a lot of contention among the beneficiaries, say it's a bunch of siblings and you're one of them, maybe you want to let someone else step in and do it just for the sake of family peace. You just want to think about those things. Now, assuming you decide, okay, I can do this. Well, you got to realize job number 1 is going to be self-care. So you really have to think about how you're caring for yourself as you're doing this. You got to pace yourself. The first day, Amanda, in her talk, really did a good job talking about self-care while you're grieving. And you got to realize, as you're settling this estate, you are also grieving, right? There were days I could knock off 5 things on my list and everything was great. Other days I couldn't face it. So what I recommend is kind of thinking of it in terms of trying to have no 0 days, right? So if you're supposed to do 5 things, at least get 1 done and then give yourself a break, right? But you want to pace yourself. I don't consider it self-care to not start on something until the day before the deadline, right? That's not taking care of yourself. But recognize when you do need to have a break. You learned a lot of skills as a caregiver. You're going to need them here, right? So asking questions. You really don't know what you don't know. So there's a handout where I put some internet links and some references where you can get general information on the process of settling an estate. And that's going to help you figure out what questions to ask for your particular situation. But don't forget your local office. So for us, Register of Wills, whatever it's called where you are in your jurisdiction, they probably have a lot of really good information as well. And our Register of Wills office, you could call up and set an appointment and go talk to somebody and they would do their best to help you. So don't forget that's another resource that can be really helpful. Be willing to ask for and get help. You're going to need persistence for sure. You're going to need patience with yourself, with others. Same thing with the compassion and the forgiveness. So I often get asked, do I really need a lawyer? It's up to you, but I think there's a lot of good reasons that you probably want to use a lawyer. So you want to think about your experience with the process. Maybe you've settled an estate before, but you haven't settled this estate before. Are you comfortable with the court and the probate process? So, excuse me. When my mom passed away, I was practicing corporate law in Delaware. Well, she passed away in Florida. So I wanted an attorney because I didn't know their process and I didn't want to have to be going down there all the time. So you also want to think about the complexity of the estate. So someone who has 1 bank account and is on Medicaid in a nursing home, their estate's going to be a little different from somebody who has a ton of investments and 4 vacation homes. You also kind of want to think about how organized are things before the person passes away versus, that's going to tell you how complicated it's going to be afterwards. I think that Brian and, I'm sorry, Jeff? Barry. I am so sorry, Barry. I know they're talking next and they're going to give you some more information on how to get yourself organized so the people after you, if you want to torture the person you're making be your executor, just put everything in 15 different boxes, put some of them under the bed, some behind the couch, which is exactly what my mother did. So just think about that in terms of the complexity as well. And again, the relationship among the beneficiaries, that's also going to be a consideration. Oops. I'm all over the place. So if you decide to hire an attorney, you want someone who's barred in the jurisdiction that the estate's going to be probated in. You want someone in good standing. You might want to call the bar association, see if they have any complaints against them. You do not have to use the person who drafted the will. Keep that in mind. If you're comfortable with them, fine. But if you're not comfortable with that person, you can get somebody else that maybe you have an attorney that you trust. Your comfort level with the attorney and the staff is really important. So make sure that you are comfortable with them. You want to understand the billing structure, how things are going to be billed. We always did things flat fee and sometimes as a percentage. Other places might do it hourly. But if you know you're being billed hourly, you're going to be a lot less likely to call and ask questions because every phone call you are on the clock. Every email you are on the clock. So you want to understand that billing structure, what's included. There's going to be additional fees for filing fees. But are you going to have to pay if the attorney copies things? Is that going to be included or not? You want to be clear in the engagement letter about the responsibilities of who's doing what. and sometimes what's included. So for example, you might have an engagement letter that specifically excludes litigation. So if one of the beneficiaries decides they want to sue, that's either an additional engagement letter or it's an additional attorney. The practice I worked for, we didn't do litigation. If someone wanted to sue, we would refer you out. So you want to just kind of understand that. So at the start of things, the person passes away or the decedent, the POA is invalid. I have had people come in 2 weeks later and they've been using the POA still. No, it is invalid. That's why you need to get the will and the probate petition filed. Now, there's some things that can't wait for you to do that. Maybe there's dependents. If it's a younger person that passes away, maybe they have kids. Think about pets. A lot of times people don't think about the pets that might be left. And you want to make sure you secure the property. So especially if there's been home health people coming in and out, you don't know who's got keys. So a locksmith might be a really good idea. And I think we've all read those stories about things happening during the services or during the wakes. So maybe get some neighbors or hire a teenager to be watching the place and watching your place when those things are happening. Funeral homes are fantastic. They do this all the time. They make life easy for you. So that's one of the things you got to do up front, but they will make it as easy on you as possible. Once you've filed the will and the probate petition, you'll get well, we call it letters testamentary. They might be called something else. Basically, it's a document, might have a pretty gold seal on it, but that is your magic ticket to being able to do anything as the executor. And you want multiple copies of it. You have to gather all the documents. So as you're looking for the will, be gathering the documents. I'm not going to go through all of them. I'm going to point out a few. Marriage certificate can be very important if there's a surviving spouse and you want some sort of spousal benefits. Mortgage or loan records, those can go either way, right? The decedent might owe a mortgage, but they might be holding a mortgage that someone owes them, in which case then it's an asset of the estate. So you want to look both ways. Military records. When you separate from the military, you get what's called a DD-214. That is a very, very important piece of paper. Back when I separated, it's like the carbon copies, and you can barely read mine because it was like the 5th copy down in the carbons. But that is what is necessary to get any VA death benefits that that someone might be eligible for. And depending on when someone served, their spouse may be entitled to some aid and attendance benefits. So that's really important to have. Savings bonds, I don't think you're going to see those very much going forward. I think they're kind of going by the wayside. People aren't buying them as much. But older people who still have them, they hide them in really weird places. So you really have to look for those. Tax returns are really kind of a very useful thing. First of all, they tell you that the person filed their taxes. Really good to know. Because if they didn't, guess what? You're going to have to deal with that. But you can take those tax returns and then cross-reference them with your bank records and the investment accounts, right? So on the tax return, it's going to list all of the interest income, all the dividends, things like that. Well, if there's a bank that they're getting interest from listed on the tax return that you're not finding records for them, there's some research you're going to have to be doing. So the only thing I'll say on the credit card statements and the other bills, a lot of us are moving towards paying things automatically. So you want to look at those bank statements and see what automatic payments are there that you might want to get canceled pretty quickly. The credit card statement might also show, I have a lot of stuff auto paid on my credit card so I can get the miles. So you want to look at that. And if the person was in business or they had a partnership, that's another thing that we'll have to get dealt with. You'll have to get an employee ID number for the estate. The estate is kind of considered a separate entity for tax purposes. So the person who passed away, up until their date of death, any income goes to their Social Security number. But once from the date of death on, any additional income, any additional interest, things like that, Those are part of the estate. So your main job is marshaling the assets, which is basically you're gathering and protecting all of the assets. You're figuring out what's in the estate, what's not. Melinda did a great talk on dealing with all the things in the estate. That's part of marshaling the assets. That's probably the biggest thing you're going to be doing when you put it all together. And you're going to come up with an inventory, which is, it's a snapshot in time. So it's as of the date of death, what are all of these things worth? So whether it's the tangible things like the coin collection or the paintings or all of the clothes or the bank accounts, it's all as of date of death. You're going to have to deal with all the debts and the bills. Now, claims against the estate. In Delaware, when you file the petition for probate, that kicks off notifications that go to several newspapers, and they're done periodically. And what those notifications do is they put anybody in the world on notice that this person has passed away, and they have a certain period of time, in Delaware it's 60 days, to file a claim against the estate. So people who think they're going to settle the estate in 30 days, no, it's at least that much time, but likely more. Towards the end, you're going to be, in Delaware, we report to the court and the beneficiaries get a copy. And basically it says, all right, here was the inventory. Here's everything we spent, all the bills we paid, all the expenses. Here's what's left. And here's how it's going to be distributed. You may want to set aside money, though, to pay the taxes, because depending on when the person passed away, you may not be able to pay the taxes for a while. My mom died in January. I couldn't pay those taxes, her income taxes for that month, until the next year, right? So there's a lot of taxes you have to worry about. It's super, I used to find it super confusing until I was doing it all the time. There's the individual who passed away, state, federal taxes for their income taxes, right? But there's also the estate. Remember, we got the EIN number for them. So, yeah, interest rates being what they are, chances are you're not going to owe anything, but who knows? You have to look at that. There's also estate tax. You know, the federal is set at a little over 5 million. Delaware follows the same thing. So if you're under that, you don't have to worry about it. If there's a surviving spouse, though, you may still want to file the form. So that's something to talk to an accountant or an attorney about. Some states have inheritance tax. Delaware does not. We're lucky that way. And there could be reasons why a gift tax form has to be filed. So it's, you know, there's a lot there. And then finally at the end, you distribute, and then you're done. So to make this process a little less stressful on you and to kind of bring the drama down a little bit, you need to manage your expectations, yours and the expectations of the beneficiaries. You got to manage the professional relationships, the workload, the record keeping, and the emotions. And if you manage all of those, then managing the issues will be a lot easier. So first of all, like I said, expect it to take a long time. That way, when it does, you're not also dealing with that unmet expectation of thinking it should have been faster. Expect the issues to come up, right? They're going to. You can spend a lot of time railing about why issues are coming up, or you can just recognize they're going to and get on with dealing with them. Be very careful about managing beneficiaries' expectations. Like I said, a lot of them think they're going to just come into the lawyer's office, the will get read, and they'll get cut a check because they've seen that on TV. That's not reality, and it's not going to go that way. So they need to understand how long things will take, and don't make promises about how much time or how much they're going to get, because you know, what if someone files a claim for a whole lot of money? They may not be getting as much as they thought. You got to really think in terms of being the fiduciary, not a people pleaser, right? If it, you know, you want to try to keep the beneficiaries happy, but you have to act as a fiduciary. And that might mean that you tick them off. That's where having a lawyer can be really useful, because I would always tell my clients, look, if someone's bugging you, just send them to me. I'll run interference. I can work that, right? So a really good attorney is going to be able to set those expectations on your behalf, and they'll back you up, right? So that's another reason why sometimes I think having an attorney can be worth it. So you might be dealing with an attorney, financial advisor, an accountant. You just want to make sure you understand the logistics. How do they want to be contacted? Do they prefer email or phone? Is there a particular point of contact in their office that they would prefer you talk to? You also want to let them know your logistics. Do you want them to email you? Would you rather they text you or phone you? You know, letting them know how best to contact you is also important. You want to manage, you know, the communication. Sometimes an attorney will say something. They think what they said was very clear, and all you heard was rah, 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 rah. Like, it's like the Peanuts parents talking. So it's always a good idea, whether you're at a meeting or on the phone, to kind of parrot back what you think they said in your words, so that you can make sure what you're hearing and understanding is really what they meant to say. Because sometimes what they said was not really what they meant to say. And so it can be really useful to just make sure we're all on the same page. You know, because attorneys are human. They can be thinking one thing and something else comes out their mouth. I mean, I know it happened to me a few times. So it's just important to make sure that everybody's on the same page. You also want to communicate if you're having issues. Don't wait till the day before the inventory is due to call the attorney and say, I really don't know how to get this thing appraised or what I need to do. And recognize that attorneys are good at many things, but reading minds is not one of them. So they won't know you're having issues unless you let them know. And they can't help you if you don't tell them. With meetings, you just want to make sure that you're on time, you're prepared, you have brought the things that you need to bring, they're organized, you've written down your questions. On the same vein, you should also be able to expect that in return. Now, they won't, the attorney or the accountant, they're not always going to be on time, but as long as it's not a pattern, that's okay, right? You should expect them to be prepared for a meeting. You know, it goes both ways because you are hiring them. So you want to make sure that when you have a meeting, it's as effective as it can be. Now, managing the workload, that's really an issue, first of all, of understanding who's going to do what. So when I hired the attorney in Florida, I was expected to do all the letters, getting date of death values, and closing out accounts. When I practiced, I did that for my clients. So it's important to know who's going to do what. You don't want to be thinking the attorney's doing it and the attorney's thinking you're doing it. That doesn't work really well. Using your calendar to your advantage can be really helpful. So I would track deadlines on the calendar. If I sent a letter, I would put a notation 2 weeks out to check and see if I got an answer, right? I would kind of schedule the things that needed to get done. And if you do that, first of all, you're kind of taking a relief off of your shoulders, because when you look at the totality of everything that you have to do, it can be overwhelming. But if you kind of put the pieces on your calendar, it gives you that assurance that I can get this done. We can do this. Also, by scheduling things, you give yourself that wiggle room to be able to take those days when, as I think it was Deb talked about shining her sneakers. Like, if you have a day where you need to shine your sneakers that particular day, you can do that because you know you've got things on the calendar and you'll get it done, right? The other thing that can be really useful is, you know, especially if you're the one doing a lot of the letter writing, use templates wherever you can, right? Because then you just have to change address and account number. You don't have to rewrite the letter every time or retype it every time. Looking at the record keeping. Right from the start, when you're gathering those documents, set up a file. You want to keep copies of everything. Be really cagey about giving out originals. Sometimes you will have to, but make sure you get a copy before you give them anything, anybody. If you send a letter, keep a copy of the letter and the attachments. You want to track contact info. So you might be dealing with 5 different banks, a mortgage company. So, address, email, phone number, point of contact, when did I send, all of that. I love spreadsheets, and I would set up a spreadsheet, and that's what I used. So I could have it all in one place, but particularly all the contact info, I would have that on one sheet, and then do yourself a favor and take a photograph of it on your phone. Because then if you're out running around somewhere, you have that if you need it. Again, tracking all the phone calls and the emails. It's really important to know who said what when. My mother had a reverse mortgage, and it turned into probably the biggest issue I had to deal with, because we knew she had it, but by the time she passed away, the real estate in Florida had tanked. So it was an underwater reverse mortgage. It also had a provision that we had 60 days to be out. So, Melinda talks about taking your time to clear things out. Now, I had 60 days and I was in Delaware and supposed to be working. So that was not fun. But dealing with the bank, I think maybe 2 things I sent them, they didn't lose. And they would have a really bad habit of sending things to her address instead of sending them to me. So one person I would talk to would tell me one thing. The next person I got on the phone would tell me something entirely different. So by having it all written down, I would be able to refer back. I would be able to say, oh no, I sent it to you on this date. By having the copies, I could just send them the copy again. So it's really, this is a form of self-care, honestly. Track your hours, your expenses, mileage, anything you spend on behalf of the estate. So if you buy stamps because you need to mail all these letters, keep track of all that. Some things you can get reimbursed for. Managing the emotions is huge. So let's be honest here. You can only manage your own, but you'll have to deal with other people's. You really can't manage theirs. So really thinking about not taking anything personally. Denise, yesterday, I know you mentioned the book, The 4 Agreements. And the day I learned this idea of not taking things personally, that was a game changer for me. Unfortunately, it happened like later down the road, but it's really important. And especially as a fiduciary, you can't make things personal either, right? So like, if there's a sibling that you don't get along with, you can't make them the last one to pick when you're dividing up all the things, right? You got to find a way to do it fairly. So don't make things personal. Don't take things personally. Again, the compassion, the patience, that's all going to be necessary for yourself, but also, that empathy that we talked about yesterday, that empathy for other people and what they're going through. So sometimes a beneficiary might call you and just go on a scree, but maybe having some empathy because they're just having a bad day. It's not personal to you, right? I think the biggest thing here, though, is unloading and processing. I wasn't a journaler at the time, so my way of unloading was to go on a diatribe to my husband, the poor man. I mean, what he had to put up with. But that gave me a way to unload in a safe place with someone who I knew would not judge. If you're a journaler, that's another wonderful way just to get it all out. Jeff talked about that fog of grief, right? You are managing, you're trying to do kind of it can be a very complex thing, settling an estate, and you're trying to do it within that fog of grief. Gina talked about processing grief. What I will say is you're going to have a whole range of emotions, and there can be a tendency, some people might, I know I was one, use that busyness of settling the estate as a way to shove everything down and not deal with things. Don't do that. Because the thing is, grief will wait. It will wait for you, and it will come up at really inopportune times later on. So there's a woman named Elizabeth Benton, and she's got a fantastic podcast, wrote a great book. I actually referred to her book in my resources for the next talk. And right at the start of COVID, she lost her baby at 2 weeks old. And in one of her recent podcasts, she was actually talking about how she's dealing with the grief. And one thing she said that I thought was really powerful was, you know what? Grief can come along for the ride, but I'm not going to let it drive. And I think that's a really good way to think about things. You need to process the grief, but you can't get so mired in it that you don't get things done and that you don't move forward in your life. So issues, I mean, I've talked about expecting them to be part of the process. Just expecting them right there can help keep you from being upset because they happened, right? You can be upset about the issue, but at least you're taking that one off the table. This is another Elizabeth Benton thing. Like, she's my mentor and she just doesn't even know it yet. Focus on the solution, not the problem. So being in the problem, that looks like, oh my God, the bank lost that letter again. Like, what is wrong with these people? They had one job to do. That's all they had to do. Now this is going to take me another 3 days. Oh, you know, I'm playing the victim. I'm only focusing on the problem. Focusing on the solution looks a little more like, okay, they did it again. All right, let me call them. Let me talk to them. Find out what we need to do to make sure they don't lose it again. Is there a particular person I need to send it to? Maybe the person I'm on the phone with has a fax number that they will go stand by it while I fax it. Whatever it takes to figure out a solution. It just puts you in control and not at the effect of the issues. You're managing the issue when you're focusing on the solution. And you want to, again, be addressing these issues from the perspective of a fiduciary. What's in the best interest of the estate? And you need to communicate, again, and ask for help if you need it. Don't wait until the last minute. That's just not good self-care. So I'm going to run through these really quick because I want to allow some time for questions. Clerical administrative snafus. I've mentioned a few. The only other thing I will say is proofread everything because people make mistakes. People transpose numbers. People spell names wrong. Just really, and we all do it. You'll do it. The attorney will do it. It's a fact of life. Out-of-date beneficiary designations, those can happen. They're more of an annoyance than a significant issue, but it's also a good reminder, and I know Barry and Brian will probably talk about this, it's a good reminder to make sure you have your beneficiaries all up to date and periodically check those. I kind of alluded to a beneficiary might want an early distribution. This is a pretty common one. And again, you have to think as a fiduciary, not a people pleaser, because someone might come to you, oh, you know, if I could just get that money a little bit early, my kid's tuition is due and I don't want them to have to drop out and whatever. That's all well and good. And you might think, well, yeah, there's enough here, so it shouldn't be a problem. And even though you might get a letter from them saying, oh yeah, I'll repay it. Well, what if something comes in with the claim that's huge? Now the money's not there and they don't want to repay it and they tell you to pound sand. You could be on the hook. So I don't know why you, in most cases, it probably will work out fine, but do you even want to go there? Right? And it just, there's so many pitfalls there. It's just something to really be cautious about. Disagreements on who gets what? Probably one of the most common things. Denise, I think you mentioned something a little bit about it, but I think what I really learned from practicing is that people really have a tendency to equate what they get with how much mom or dad, and I think it's especially with parents, how much mom or dad loved me. And any issues among the siblings that were there beforehand, like the sibling rivalries, mom always loved you best, that's going to show up here. Because no matter how fair everyone thinks it is, they're not going to think it's fair. Like I always tell my kids, fair is a weather forecast, right? Because what one person thinks is fair, the other person thinks is totally unfair. It's a thought. It's not a reality. So you got to be really careful there. And going back to Melinda's talk about cleaning things out, as the executor, you got to be very cautious about what you give away or what you might get rid of early on. Because I had one executor and dad was in a nursing home and he had some really nice little quilts and Afghans. And he had a lamp in his room and some pictures. Well, when dad passed away, he took the pictures, he took the Afghans, and he left the lamp figuring it might be good for somebody else. Well, there were issues among the siblings. And when it came to dividing up the tangible goods 3 ways, there was the other brother who was wondering, where's the green lamp? And he was livid that there was no green lamp. And he wanted the green lamp. I can't tell you how many emails I got about the damn green lamp, but it's really affected how I talk to my kids about all of this, because I really make it clear to them, first of all, I don't owe you anything. I don't have to leave you anything. You are not owed a thing. And I think sometimes kids feel like they are owed. They don't realize this is a gift. And so, yes, if I name you as a beneficiary, you have legal rights under that, but I don't owe you anything. I can leave you 1 spoon if that's what I want to do, and I can leave the other guy the Maserati, my choice. Now, I tell him I'm dividing it all 4 ways, but I am working really hard to spend it all. So don't expect a thing. But it's like beneficiaries don't realize it's a gift. And I think that causes a lot of issues. The other one I hear a lot, I'll get to the where'd the money go, is it's not fair, which is kind of a variation on the disagreement of who gets what, right? Where did all the money go? Well, you know, I think we all know as caregivers, it's expensive. Caring for someone in those final days can be really expensive. And if somebody's not involved along the way, like there's always those siblings that kind of don't do anything. They're very hands off and they show up, and in their mind, mom and dad were really well off. Now, it may not have been reality. Maybe mom and dad were in hock up to their ears, but they think mom and dad were really well off. And so they want to know where the money went. And it's your fault that it's not there. And you better explain yourself because you obviously wasted it all. And that's where you just have to not take it personally, go back to that record keeping, and use that attorney to run interference for you. Because I think having that third party who can sit down with the records and lay things out can be really useful. So, you know, I want to just end by saying this is a really hard process and you're doing it while you're grieving. And it can kind of feel like you're severing that final connection with your loved one. So that kind of can make it even more emotional, right? But the way I want you to think about it is this is one final act of caring that you can do by making sure that their wishes are carried out. It's kind of like it's the final gift that you can give. So with that, if anyone, I mean, I know there's some people who might watch this on the recording, so feel free to contact me with questions. And even anyone here, if you think of something later, feel free to get in touch with me. But for now, I'm happy to take any questions. Let me just stop sharing.
And Leslie asked a question in the chat room. Leslie, are you okay if I read it to Joan?
Absolutely. And then I have another question to ask. So
you go for it. Leslie, you go for it.
No, I was just going to ask on behalf of a friend of mine who's having a horrible time with her brothers, and she is the main caretaker of her mom. And the brothers, you know, she is going to inherit the home. So if she wants to, you know, fix a broken board that her mother could fall through the floor, the brothers are like, well, you only want to do that because you're going to get the house one day, kind of thing. And I get my actual question for you is there a way that she can have access to this information? Or how does she contact you, or do you have some sort of book or other, or your website has this information?
I don't have a book, and this is a little off topic for the coaching that I do. I did in the handout, there's a lot of resources. Okay. So those can be kind of helpful. The one thing I will say, and I mean, this is just general, this is not legal advice, it's way more common sense. If she feels like there might be questions later about anything she's doing, have her take a picture of the broken board, have her keep receipts. That record keeping and that kind of thing can be super, super useful. And if there's an attorney that she's been working with in terms of caring with her parents, that's a really good question to ask them, because they can really pinpoint in your particular jurisdiction and in that particular circumstance, what would be considered a reasonable thing to do, right? Like fixing a broken board is one thing versus maybe ripping out all the flooring and putting in some really high dollar mahogany or something, right? So that's where talking to an attorney can be a really useful thing. I know people kind of shy away from it because of the cost, and I know there is a cost, but especially with settling an estate, involving an attorney up front can sometimes save you money. You know, and I think Barry's making a really, I can't see the chat, but you know, there's legal ways, but then there's also just talking it out, you know, and that can be hard.
So Barry is recommending perhaps a social worker meet with the family. You
That's a
can
very
look
good
to,
suggestion.
for instance, if her caree has an Alzheimer's diagnosis, you can look to the local chapter of the Alzheimer's Association for a social worker. They have social workers on staff that do family meetings and mediation. You can also look to the Area Agency on Aging if they have a social worker on staff that could help. You could also look to hire someone privately who's a mediation expert who could help with the family dynamics. Now, of course, that all depends on the brothers actually being open to attending these meetings, which sometimes is just an impossibility.
Yeah, it's been a tough situation for her. But then my other question, I can't even see anymore in the chat. Let's see. Oh, the part about distributing the other assets, and my dad had requested for years that we, you know, write down what we want and whatever. But my sisters and I got along really well, and we just sat down and went in age order, and I was the youngest, and I didn't care. I figured the worst I could ever do is get my third choice on any round.
Yeah.
And we were very good, but let's say for my children, I don't know that they'll be that way when I'm gone. They're pretty competitive. Is there a way to stipulate in a will that this is how you want your personal belongings to be distributed? Anything that's left behind?
Yeah. I mean, there are ways you can specify how that's supposed to work.
Okay.
You can specify around robin, you can specify they just divide it. My mother actually left everything to me, everything in the house, because I was the only girl, and she had this idea that daughters-in-law will not take care of things. So it all came to me, and then I just parceled it out because I didn't want it all. And so I just kind of figured out who wanted what. There are ways to do that. There's also, I think it's probably in most jurisdictions, Barry, if I'm off on this, let me know. But in Delaware, as part of your will, you could specify that you would have an attached list, and that would be something you could update as often as you wanted without having to do a codicil to the will. So it might be, you know, child A gets the china, child B gets the silver, This one gets the painting, and then that one ticks you off, so that you cross that out. They get the plunger. It's whatever you want to, that gives you the ability to kind of change it as you go.
Okay.
So there is some ways to do it in a way that's flexible without having to always redo your will.
Great. Thank you.
Sure.
I
And
have
I think it's all, one thing I will say, as we age, I am working, like, even now, I'm like pushing 56. I'm working on like giving stuff away now because I don't want to have them have to deal with a lot of stuff later. And if they need it now, it's better, right? So the more you can do while you're alive, plus you get to see them enjoy it.
So I have a couple questions for you, Joan. You had mentioned early on that if we didn't feel up to being the executor, we could actually use someone else. Could you tell us a little bit about who our options are?
Well,
then,
typically, yeah.
oh,
Go ahead.
And then part B is, if we do decide to become the executor, what kind of reimbursement can we justify or expect?
Okay. So typically when we do a will, we'll put like backups in the will. So if the first person can't, like maybe they passed away. If the first person can't or won't, then there's usually one or two more listed. There's also the option of hiring a professional. And sometimes in wills or trusts, they might list a professional as like the last option. So that if no one in that list wants to do it, then you hire like a trust company could do it. Now, as the executor, most wills will say, that you can take, we always phrased it when I wrote them, a reasonable compensation. And Delaware has case law that kind of puts a parameter around what's reasonable. So, you can take that compensation and you can be reimbursed for any out-of-pocket expenses. So, for example, I paid for the funeral and then I got reimbursed for that later. If I had to buy like packing boxes and moving supplies, all of those sorts of things, that all goes with the estate as well. The other thing I'd like to mention that I didn't mention is you have to be careful as the executor when you're dealing with creditors, because I had quite a few that would really try to push, and they would try to tell the executor that, hey, if there's not enough money in the estate, what are you going to do about it? And they would almost lead them to think that they were on the hook. And that is not true. Unless, say you have a joint credit card, okay, you're on the hook for that personally, but not as the executor, right? And as even the other beneficiaries, like the kids, if the parents die with a lot of debt, the kids, unless they're co-signers or something like that, they're not responsible for that debt. But there are creditors that are out there and they're not always ethical, let me say.
We have just 2 minutes left. If anybody has one last question, please feel free to unmute yourself or type it out in the chat. This was really helpful, Joan. I found your explanation of the steps to be very clear and concise, which makes it feel like, okay, I know this is going to take a while, but we can get through it.
Yeah. And it'll be, the particulars that would fall under all those categories will vary for every estate, right? So it'll look totally different one estate to another, but those are kind of the themes.
I think Brian might have a question.
Yeah, I can ask one that I don't think will take very long. Jonah, I'm interested, you mentioned that it can take a while to, like a month minimum, but it can take a while to wrap up an estate. How long can some estates linger, and what are some of the things that you have seen cause them to stretch, from a couple months to a few years?
I had one that was going on 5 years. And the reason it had to stay open was the dad had passed away and the daughter was settled, was the executor. and dad was a crime victim who was owed restitution. And so this restitution check would come every month for like $35. And I never could get her to fill out the stuff that was needed and go back to court to get it changed to come to the estate or to come to her as the beneficiary. So it just kind of stayed open. And when I left that job, it was still open. You know, other things I've seen is where the house is left to multiple kids and then they can't agree on what to do with it. And if they didn't come to some agreement pretty quickly, we would just retitle it so that they're all co-owners, and then they would have to deal with it. But, you know, we would try to help them figure it out ahead of time, because having that situation where multiple siblings own a house is just not very good.
Not ideal.
It does, you know, right? Like,
Right.
because then you get into the fights of who's going to pay the electric bill, who's going to pay the repairs, and who gets to use it, all of that. So yeah, I mean, there are some that go longer. I think typically 13, 14 months was pretty common.
Okay, thanks.
Sure.
Okay. Thank you, Joan. This was awesome. What a great resource
Welcome.
for us to have as well.
Sure. All right.
Okay.